Hello everyone, welcome back. Today I want to do a gun rights battle plan as I see it developing in 2023. Okay, so this isn't, I don't think this is so much a coordinated effort, so much as a lot of individual gun rights groups and gun rights lawyers, kind of doing their own thing, but it's going to naturally take them in a similar direction, kind of like, water rolls downhill. It usually ends up at the lowest point. Well, that's kind of what I see happening with the gun rights battle plan. Okay, I first of all, I gotta say I have a lot of confidence in the pistol brace ban being struck down as unconstitutional. I think that is almost a 100% assured win. I've done satire videos on that just because I have so much confidence in that. The reason why I have so much confidence in that is because, first of all, that case is being run down in the Texas area, right? I think that's the Fifth Circuit Court. And they have already declared that in one case, they had declared that the bump stock ban was unconstitutional, and they cited, I believe in that case, the NYSERPA v. Bruin decision that basically said that any gun control that didn't exist in 1791 when the Second Amendment was ratified is unconstitutional. So we know already that the judges down there are thinking in that direction. Okay, and then there's other cases out there. One that came out that basically said that marijuana users, could possess firearms, right? Because the mere possession of marijuana doesn't necessarily mean that they're high while they're carrying it. Okay, so that's another indication of where that's going. Again, that court cited the NYSERPA v. Bruin decision, where again, if that gun control didn't exist in 1791. Unconstitutional. Okay, and another really important one is a recent case, federal case that came out that said that a restraining order, right, a civil restraining order, where you have, let's say, like two people fighting in divorce courts, a civil restraining order cannot prohibit somebody from owning their firearms, and that's really important because basically with a lot of these divorce cases, the lawyers, if it's going to be like a hostile divorce case where two sides are barely fighting with each other, lawyers pretty much automatically, file a restraining order as a matter of natural course, and it's and then basically you have to go to court and try to get it removed, and then even if you get it removed, it's not like the other person gets penalized. It's not like the other person gets penalized for falsely filing a restraining order against you. Okay, so what it really comes down to is they're removing people's rights, right, their Second Amendment rights, without due process, right? They haven't been convicted by a jury, and all of a sudden, just because there's this restraining order that's issued by a judge without a proper trial, they lose their gun rights. Okay, so that's a really big, important case, and the Democrats are trying to frame this as the courts basically allow domestic abusers, gun rights. Okay, that's how they're framing it. But important thing there has been no conviction. Okay, all there has been is an accusation. Okay, there has been no conviction, and very important for us to, because we gotta know how to respond to these people. Okay, so the correct response is, if that person is so dangerous, get him convicted, right, and then put him away. All right, because my position is that if you're safe enough to be out in the streets, you're safe enough to own a gun. Okay, so if these people are so dangerous, then go get the conviction, right? But you can't just take somebody's gun rights away, from a restraining order where there hasn't been a conviction by a jury of that person's peers. Okay, so all these things are indications, right, of some serious winning coming down the pipe. Okay, I mean the brace decision, the pistol brace decision, I think that's 100% guaranteed. Simply because there's just so many of them out there, it affects millions of people. By contrast, when you look at other cases like the forced reset triggers, or the frames and receiver ruling that the ATF made, it doesn't affect millions of people, right? It affects thousands or maybe even 100,000 people or so, but it does not affect millions of people in the same way that the pistol brace rule does. So there's two things that I'm afraid of, right, as far as this overall battle strategy that I'm talking about here. Number one, I'm afraid of some of the older Supreme Court justices passing away, right? We're all born with an expiration date. So Justice Thomas, our greatest supporter, and also Alito, these guys are up there in the years. If these justices pass away, their replacements are going to be very anti-gun. And important for us to keep in mind is that while conservative justices are very slow and methodical and careful with how they proceed, okay, Democrat-appointed judges are going to be very aggressive, erratic. They're gonna if they come in, they're gonna make rapid changes really fast. So that's the unfortunate thing for us, is that our judges move very slow, their judges move very quickly. So that's the first thing that I'm afraid of. The second thing that I'm afraid of, right, I'm not afraid of, cautious of, right, is the ATF and the gun control states like New York, New Jersey, California, and Illinois pulling back, okay, starting to strategically retreat. Okay, that's the other thing, because I don't want them retreating. Okay, I want them, I want to pull them out, lure them out into the open where they can be easily attacked, because right now they are in very weak positions. They're clearly, what the things that they're doing are clearly unconstitutional, and I want to keep them there. Okay, so the worst thing that can happen is the ATF starts reversing some of its positions. And in fact, I was very surprised that the ATF came out with the pistol brace ruling after the United versus Bruin decision, because I thought that, hey, they sort of writing on the wall. I expected them to back away from that, right, and just try to defend the frame and receiver ruling. Okay, but they went ahead and they actually issued that stupid pistol brace rule, which I think they're gonna get completely destroyed on that. Okay, now why would they do this, right? Why would they do such a thing? Why would they take such a weak position? Well, I think basically they are they're basically doing what they are told to do by the Democrats, who are basically doing what they're kind of being told to do by the anti-gun groups. Okay, so important thing to understand here: our motivations versus the motivations of the anti-gunners. Okay, because this is a really important part as far as the overall strategy. We on our side, right, the gun rights side, we're interested in gun rights. Okay, so we're all motivated with freedom and individual liberty. Okay, and we don't want big government telling us what to do in our lives, so we're motivated by individual freedom, individual liberty. On the anti-gun side, what are they being motivated by? Right, they're certainly not being motivated by safety and stuff like that. That's what they are being motivated by is Bloomberg's money. Okay, for them, for these anti-gun groups, this is a business, right? They're trying to figure out ways to keep that Bloomberg money, those billions of dollars that Bloomberg's throwing at them, right? They want to keep that money coming. So we're trying to win. They're trying to just keep money coming to them, right? Because they're basically making a living off of fighting to suppress our gun rights. So they're in it for the money. So very important for us to understand the two motivations and why our position's a lot stronger. They're just doing it for the money. We're doing it to preserve and extend our liberties. Okay. So what I want to do now is first, let's take a look at the two sides of this battle, because there's basically like two fronts that we're fighting on. One is where we're fighting the states and the cities, right? States like specifically New York, New Jersey, California, Illinois, right? Where they came out and they, after the NSRPA versus Bruin decision, they came out with really radical laws that actually flew in the face of that Supreme Court decision. Okay, so that's the one side of it, and then the other side of it is basically the federal government, particularly the ATF, which is a federal bureaucracy. Okay, so now, important thing to understand here is that the Supreme Court has a lot more power over the federal bureaucracies, right? Because they're part of the federal system, and they're able to direct their orders at specific agencies and specific, at a specific leadership in those agencies. And for the most part, those people are really interested in self-preservation. So the Supreme Court, I believe, is going to be a lot more comfortable against making immediate orders against these federal bureaucracies. Now, as far as the states, right, the states and the cities, the Supreme Court does not have any enforcement abilities. Okay, so the Supreme Court depends on the lower courts in the states for enforcing its opinions. Right, that's why they call them opinions. So they can't specifically tell the lower courts what to do, and if they try to do it, and the lower courts ignore it, there's nothing that the Supreme Court can really do. Okay, so that's why they have to kind of coax them into following their opinions. Okay, so that's why I think that we're seeing that the Supreme Court is being really smooth with the states. It's issuing opinions. As these opinions, as these incorrect decisions come back to the Supreme Court is sending it back down to the federal courts in the states and telling them that you're wrong, reconsider what you said in light of the NYSERPA versus Bruin decision. So they're trying to coax the states because they recognize that they don't have these enforcement powers. Now on the federal side, they can tell the ATF what to do, issue just an order, and it would be expected that the ATF or any other government bureaucracy would follow that order. Now, other important thing is, on our side, we have the ability to decide which courts we're going to fight them in. Okay, so one of the courts that is very popular for fighting the ATF is the Fifth Circuit down in the Texas area. Okay, so that is the Fifth Circuit is the one that basically that recently gave us that win with the bump stocks, where they said that the bump stock ruling was unconstitutional. Now, they didn't quite go far enough. They said that it was wrong, and they sent the appeals court sent it back down to the circuit court, and they basically left it open to the circuit court and said, hey, what the ATF did was unconstitutional. You figure out what the correct remedy for this is. Okay, so now in doing that, what they did is they did reference the NYSERPA versus Bruin decision, and they basically said the reason why it's unconstitutional is because that nothing of that type existed in 1791. Right, that's the standard that has been set by the Supreme Court as far as gun control. So if a gun control law did not exist in 1791, it's unconstitutional. Okay, so that's really the only time period that matters. So that's the standard that the Supreme Court set, and we can see that the Fifth Circuit is following that standard. Okay, so I believe that they are very quickly going to apply it to the pistol brace cases as they come up. Now with the frames and receivers case, I also believe that they're going to apply to that. But the great thing about the pistol brace issue is that it affects millions of people. Okay, so I think we're going to get a much faster, quicker response. We're going to get a bigger victory out of the pistol brace ruling, and I think that pistol brace ruling, because these victories build upon each other, right? So the victory from the pistol brace ruling, which I think is going to come down initially as a restraining order, and I expect that that's going to come any day now. Okay, so I think that once they set that tempo, I think that's then also going to apply to the frames and receivers. Then that's also going to apply to the Texas suppressor case law, the ruling. The case that's running around down there, and then the FRT case that's somewhere in the system also being fought. Okay, so the other thing now I'm going to talk about as far as the strategy that I see developing, two sides that it's being attacked, two approach angles. Number one, ATF overstepping its authority, right? And they're referencing the West Virginia versus EPA case, right? Where it said that these agencies cannot make law. So that's the one direction that they're attacking it from. And the other direction that they're attacking it from is the NYSERPA versus Bruin decision itself, that again basically says that if the gun control didn't exist in 1791, it's unconstitutional. Okay. Now within that, there's also a different approach that I see that I believe is going to develop, and that's the approach that, here's the thing: when the government takes a position, right? In one case, the government, the ATF, they cannot later on in another case just easily take a completely different opinion, because what the government said in one case is going to be used against them in the other case, right? Because the government is a single body, in a manner of speaking. Okay. However, on our side, when we're suing the government, right, you can have one person suing the government from this side, making one argument, and then another person suing the government from this side, making a completely different argument that even contradicts this one. And that's okay, because these are two separate people. So we, on our side, right, we get to make contradictory arguments, whereas the government doesn't get to make contradictory arguments. And that's also, that's going to be a big advantage to us. So the example that I'm going to use here, right, is that, for example, on the pistol brace side, right, we can come in on one side and we can say that, hey, the pistol braces are nothing like stocks. ATF said that they're not stocks in earlier rulings, and basically, they're not stocks. So we can make that argument. We can have one person in one case make that argument. Okay. Once we win that once we win that case, that says that the court comes down and says, yes, you know what, you're right. The pistol brace stocks are not stocks. The pistol braces are not stocks because that's what the ATF said themselves. Okay. Once we win that, right, then you can have another person, right, make a lawsuit against the ATF, and they can say, hey, ATF said that the braces are stocks, right, and I believe that, right? They're going to say, we believe that, but here's the thing: because there's already millions of them out there, right? There's millions of braces out there that have been put on these AR pistols, and the ATF themselves have at one point said that they were stocks. Now stocks on AR pistols are common use. So now we're talking from the other direction. So you can have from one direction, we can say that the braces are not stocks, and in the other direction, we can say that the braces are stocks, and hence common use, right? So we get to make both arguments. ATF or government in general can't make that. They can't make that double argument, right? They have to take a position and they have to stick to that position. So this is same deal here is gonna apply to the frames and receivers. Okay, on the one side we can argue it from the frames and receivers are not firearms because they're an 80% form, so they shouldn't be required to have a serial number. Once we win that case, right, then we go back to court, right? We have another person go back to court, right, and then that person can argue that, hey, ATF said that they are that the 80% frames are firearms, and we believe that that's the position that we're going to accept. But since the other court said that they don't need a serial number, now we're saying that none of the firearms out there are required to have a serial number, and hence we should all have the ability to scratch off the serial number on any firearms that we have, right? So basically, this is a way to attack the GCA, right? The Gun Control Act. So we get to attack this from two different directions, because we send one person into it to argue one way, we send another person to argue another way. There's really no connection between these two guys, so it doesn't matter that this person and this person, their arguments contradict each other. We can do that, but the government can't do that. They can't take contradictory positions, okay? Basically, same deal with Texas with the suppressors. We can find a way to argue that from both sides. And the force reset triggers, right? That's a great, that's a great opportunity to, on the one side, argue that, you can have one person arguing that the force reset triggers, are not fully automatic. Once that person wins, right, then we go back. We get another person to go back into the courts, and that person can argue, hey, ATF, force reset triggers are now legal. ATF has said that they're similar to machine guns, so hence the machine guns should also be legal. So that basically, step by step, we can knock out the entire NFA. Now, you can't take out the NFA in one shot. You got to do it piecemeal like that. It's going to take lots of little cases, lots of people arguing it back and forth, and just like slowly chipping away at. Okay, so moving on, next thing I want to talk about is this concept of common use. Okay, because for the moment we're using that as an ally, right? We're using that to make our case that firearms that are commonly owned cannot be banned. Now, I want to go because here's the thing: the Supreme Court kind of, because this is also a limitation, right? The idea of common use firearms cannot be banned might, I'm not saying does, but it might imply that firearms that are not in common use, right? Like say in the future, like lasers, right? When laser guns start being produced, an argument, somebody might be able to make an argument, hey, laser guns are not in common use, so they aren't protected by the Second Amendment. And my position on that is the Second Amendment covers past, current, and future weapons. But anyway, the idea here with common use, the way I would argue, how that should be applied is common use doesn't just apply to common use firearms by civilians, but common use also includes military, right? So if the military, if firearms are being commonly used by military, and not just the American military, but any military around the world, they are in common use, okay? So common use to me includes military arms, okay? So that's something that down the road, when we've won everything up here, right? After we have completely destroyed the Gun Control Act and the NFA, down the road we have to come back and deal with this common use, right? Because that down the road that can be used against us. So the common use has to be expanded so that it clearly includes firearms and arms that are used by the militaries around the world. Okay, and the other thing that's also kind of bothering me is the 1791 standard that the Supreme Court has set. So the Supreme Court has said that the only gun control laws that are constitutional are the ones that existed in 1791, and for now that's our ally, right? We're going to use this to strike down all this other gun control that did not exist in 1791. But after we have won that, right, I want to actually come back to this, and my argument at that point is that whatever gun control existed in 1791, that's also unconstitutional, right? And the reason why it's unconstitutional is because after the founding fathers sat down and negotiated and wrote the Second Amendment, they said shall not be infringed. Okay, they did not say shall not be infringed. With the exception of gun control that existed in 1791, they could have done that, but they chose not to. They gave a blanket statement: shall not be infringed. So down the road, okay, not now, but down the road, I want to come back, okay, and redefine this 1791 standard to make it clear that even the gun control that existed in 1791 is unconstitutional, okay? So now this comes back, because people are going to jump up and say, well, how about felons? You're saying that felons should all have, violent criminals should all have access to guns? And again, my answer to that is, if they're that dangerous, convict them and put them in jail, okay? But once a person is released from prison out into the general population, all rights restored, right? Basically, if you're safe enough to be on the street, you're safe enough to own a gun. People released from prison are going to have access to far more dangerous things like cars that they can drive down a busy sidewalk in Manhattan and kill a lot more people than they would with a gun. Okay, so that's my answer to that. So hope you guys enjoyed this. I know we went into a lot of detail here, but I wanted to kind of like sit back a little bit and kind of look at the overall strategy that I see developing for fighting gun control. And I think that we have a huge advantage, and part of that advantage is the fact that is we're trying to preserve liberty and freedom. The anti-gunners are just trying to milk Bloomberg for his money. So I think we're in a really good position. So thanks for watching. Spread this video, pass it around. I'll talk to you all soon. Oh, make sure you guys are following me on the uncensored channels, right? I'm on BitChute, I'm on Rumble, I'm on HugeTube, and I'm on Odyssey, okay? And if any new platforms come come up, I'm going to get myself on those as well, because YouTube has already shut down one of my channels, and they're most likely going to shut down the rest of my channels sooner or later. Okay, and the strategy that I did a prior video on, the strategy that I came up with, well, not I came up with, but I heard from somebody else, and I think is a great idea. A good way that we can stop the YouTube censorship is by going to other channels that are not gun related, right, and just randomly flagging their videos as harmful and dangerous, because that's going to tie up the YouTube censors, right? And now they got to go watch those videos, and if they're busy watching those videos, they're not watching the gun videos, you know. So it's just tying them up, wasting their time, and you're not going to hurt those channels, because after they finish watching a channel about growing grass or something, they're going to say, okay, this is not, you know, basically they're not going to do anything to those channels. So we're not harming those videos or harming those other channels, but we're using them to basically just tie up the YouTube censor. So thanks for watching. I'll talk to you all soon.